you on the matter of Mitsui Sumitomo Insurance Company Limited and Dassault Aviation SA.
Just one moment, Mr. Smith, if you'll... Yes, good morning.
My Lord, good morning. I, along with Mr. Joseph, represent the appellants. My learned friends, Mr. Stanley KC, Mr. Leslie, Mr. Carroll Green, represent the respondents. As you will hopefully seen from the skeleton argument, my lords, this appeal concerns the scope of contractual prohibition on assignment, and in particular, two overlapping questions. Firstly, whether the prohibition applies to involuntary assignments and/or assignments by operation of law, and secondly, whether it applies to an assignment to an insurer, which is akin to subrogation. Now, by way of introductory remarks, I'm just going to set the context in which those issues arise. I'm going to give the court an overview of our arguments, and then I'm just going to set out the structure that my submissions as a whole are going to take. So far as context is concerned, the point arises as follows. The respondent, Dassault, as I'm going to call them, is a French company who agreed to manufacture and sell two surveillance aircraft to Mitsui Bussan Aerospace, or MBA. It was understood between the parties to that sale contract that MBA would, after taking delivery of the aircraft, modify them somewhat and then sell them on to the Japanese Coast Guard, or JCJ. The contract stipulated delivery dates for the aircraft and also provided, in certain circumstances, that Dassault would be liable for delayed delivery. The contract also, as we'll see later on, provided that in the event of such delay, Dassault would be liable to MBA in respect of any such liability as MBA had itself to JCG under the subsale. Now, MBA, during the life of the contract, took out insurance in respect of the risk of the aircraft being delayed in their delivery and in respect of the risk of MBA incurring a liability to the JCJ. And that policy...
You're going to have to keep your voice up, Mr. Smith, because you're fighting various noises outside, as we always do in this court.
My Lord, yes. I'm very pleased. It's a rare occasion where I'm told that I'm speaking too quietly, so I will take the opportunity to turn the volume up. The insurance policy was with the appellant, Mitsui Sumitomo Insurance, or MSI, as I will call them, and that policy was subject to Japanese law. The aircraft were delayed in delivery, and MBA incurred a liability to the JCJ for that delay. As a result, MBA made a claim under the policy. That claim was accepted by MSI and a payment was made. Now, at that point in time, MBA's rights against Dassault under the contract were automatically assigned to MSI. And that assignment took place by operation of Japanese law.
MBA's rights under which contract?
The sale contract between MSI and between MBA and Dassault, the primary sale contract.
So they paid out damages under the subcontract, payable under the subcontract, and the rights under the sale contract were automatically assigned.
Correct, my lord, yes.
On the terms of the Japanese statute. Uncontroversial, is that?
That is uncontroversial, I believe. There was an issue before the tribunal that I'll touch on very briefly as to the mechanism of transfer of the rights under Japanese law, whether it was pursuant to the terms of the policy or whether it was by operation of Japanese law, but it's common ground before this court, as it was common ground for Mrs. Justice Cockerill, that the assignment took place by reference to the Japanese Insurance Act and by operation of law.
Yeah, my point is that the assignment was of the rights under the sale contract to sue Dassault, and the payout under the policy was in respect of liability under the subcontract.
Correct, my lord. And just to be clear, the assignment wasn't one that specifically refers to my client, MBA's rights as against Dassault under the sale contract. It was a general assignment of rights of recourse. Perhaps I should just show you, if you look in the supplementary bundle, tab 1, we have the relevant excerpt from the Japanese insurance law. It's at page 3 of the supplementary bundle. And you'll see exactly halfway down the page a heading in brackets, it's a translation of the Japanese word, subrogation regarding claim. Article 25(1). An insurer, when the insurer has made an insurance proceeds payment, shall, by operation of law, be subrogated with regard to any claim acquired by the insured due to the occurrence of any damages arising from an insured event. So it's in general terms any claim that the insured may have due to the occurrence of any damages arising from an insured event. I would also draw your lordship's attention.
Well, is it due to the occurrence of any damages arising from an insured event?
Well, my lord, as between MSI and MBA, it's been accepted that the effect of this provision that I've just showed you is to transfer or assign, perhaps as we would say as a matter of English law, MBA's rights as against Dassault under the sale contract. I don't think any particular issue has ever been taken before the arbitrators or indeed the court below as to whether or not it did in fact, as a matter of Japanese law, have the effect of assigning those
Yeah, but if it
rights.
didn't, MBA can still sue Dassault
Correct.
under the contract.
And if it didn't,
I mean, because somebody's going to say at some point in this case that probably you, that it beggars belief that a non-assignment clause under an English law contract can affect some the ability of an insurer to sue, which you would expect as being perfectly normal if the insurer is paid out. English law contract, English law of subrogation would allow the suit to take place, but because of this different way of doing things in Japan, they can't, and therefore they're completely inhibited ever. The insurer is completely inhibited ever from suing, and that beggars belief and is wrong, and that's why Lord Collins and Mr. Smuha thought they as they did, and that's all on the premise that MBA don't have any other claim. But if MBA do have a claim against Dassault because this has not taken effect, then that might be relevant.
that might be relevant indeed, my lord. We would say that if indeed that was Dassault's position, that would be a complete defence to MSI's claim. They would simply say Article 25 of the Japanese insurance law has not applied at all.
Has it been pleaded out? I'm afraid I haven't looked at all the pleas.
There was, the jurisdiction issues were fully pleaded out in the arbitration. There was my clients were required in the underlying arbitration to set out an initial memorial which set out their case as to why the tribunal had jurisdiction, and there were then a series of exchange of counter memorials, reply memorials, where the parties pleaded out their case on jurisdiction.
Just jurisdiction.
Just jurisdiction, but it's key because the very point that Dassault took below and is taking now is not a pure jurisdiction point in the sense they're saying, yes, MSI has a claim, but they're bringing it in the wrong forum. They're saying MSI doesn't have a claim at all, and therefore it cannot rely on the arbitration agreement at all. And if MSI didn't have a claim because there has been no transfer under Article 25, then it would automatically follow that MSI couldn't rely on the arbitration agreement in the sale contract, and that would be a ground upon which the jurisdiction of the tribunal could be challenged. But that point wasn't taken. Japanese law evidence was obtained. We've got some of it and perhaps all of it in your bundles.
And Japanese law evidence accepts that this claim did pass under Article 25.
Yes, my lord, and it's
A claim under the sale contract passed under Article 25 to MSI.
my lord. Yes, it did accept that.
Nobody said they didn't.
Nobody said they didn't, and it was also accepted that Japanese law governed the effect of the supposed assignment as between MBA and MSI. So that was an issue to be determined by Japanese law.
Yeah.
So it is, whilst...
So really I'm worrying about nothing.
Whilst, my lord, I take your point about the wording of Article 25, perhaps, and it may be a translation issue, not being 100% apposite to cover the transfer of rights I'm talking about, it has never been an issue that there
Show me
was.
the words in Japanese, will you, Mr. Smith?
Probably the second line, my lord.
I once appeared in court when a judge of the High Court said that all judges understood all languages, which seemed a bit adventurous even then.
Well, I will defer to you then on any issues arising from the Japanese terminology, my lords.
But I mean, Mr. Stanley will get up and say something different. I'm worrying unnecessarily because this has not been an issue. There was evidence of Japanese law,
Right.
and so I really have to accept, or we have to accept, the premise of the debate, which is that the claims under the sale contract were assigned under Article 25 as a matter of Japanese law, and the question really is only as to the meaning of Article 15 in that context.
My lord, precisely, yes.
Yeah.
My lord, I think that's broadly right. With just this qualification, because as my learned friend says, the only issue that the tribunal has reached is jurisdictional. The only question it had to decide was if there is a claim, is it one that MSI is entitled to bring? The issue as to whether there is a claim which has been assigned is, in a sense, down the line. So I think the tribunal was probably right to focus on the point that the question is effectively whether there has been, if you assume that there has been a transfer to MSI, which is the basis on which MSI makes the claim, is that transfer an effective one for the purposes of the contract? Because if it is, the claim is correctly brought before the arbitrators, good or bad claim that it might be. And if it's not correctly brought before the arbitrators. And I think that probably is why that issue would not have arisen at that stage.
But the request for arbitration, paragraph 5.6,
yes,
says consequently pursuant to Japanese law, the assured lost the right to bring a recourse claim.
yes.
So that was very specifically in, and I think the dissenting arbitrator said, well, he wasn't going to get into that because MBA aren't here.
No.
But I'm not aware of a response to paragraph 5.6 of the request for.
No, but it must follow from, I don't think it's ever been submitted by us, and it isn't part of my case here, that a consequence of deciding that MSI has not acquired a right would be deciding that MBA had lost it and it had somehow vanished into the ether. That doesn't seem to be a legally logical conclusion.
There's something a little bit artificial about all this, because once the point is taken about then the automatic reaction would have been to join MBA.
Well, for whatever reason, that hasn't been done.
Sorry?
For whatever reason, that hasn't been done. There's no evidence about where that stands at the moment. I can take instructions on whether I can tell you, but it isn't my case that if the transfer of rights has not, pursuant to the contract, has not taken place in favour of MSI, then it must follow that there has been no transfer and those rights remain with MBA. There's no legally logical alternative.
Is there a time bar?
Not yet, and that's what there has been. There has been a request. I can put it this way: there's been a request from MBA to toll the time bar, but it is common ground that the time bar has not yet expired. Thank you. I'm sorry to interrupt my friend. I hope it was helpful, not controversial.
The only other point I would touch on for now, my lords, by reference to Article 25 of the Japanese Insurance Law Act, is the use of the term subrogation. They refer to the claim being subrogated, but we as English lawyers would regard that as more an assignment of right if we were characterising it in accordance with English law concepts. So MSI sought to bring a claim against Dassault, and as my Lord Justice Coulson pointed out, that was on the basis that only MSI had the right to bring such a claim, and MBA had lost it. Dassault challenged jurisdiction on the basis that the sales contract contained the Article 15 prohibition on assignment, and so said that the effect of that was to make the assignment of rights of no effect so far as Dassault was concerned. The jurisdiction challenge was heard in the first instance by the tribunal. You'll see it was a very august tribunal. Lord Collins of Mapesbury, Mr. Smoohar KC, and Mr. Crooked KC. The tribunal rejected Dassault's jurisdiction challenged by a 2-to-1 majority. Now, the actual basis of Mr. Crookenden Casey's dissent was very narrow. The tribunal were unanimous in construing Article 15 as not applying to assignments by operation of law, but as only prohibiting voluntary assignments. See that from paragraphs 160 to 162 of the main award and paragraph 4 of the dissent. The tribunal also unanimously accepted that the transfer had taken place pursuant to Section 25 of the Japanese Insurance Law Act. Now, the majority said that because of that, the transfer was one which was by operation of law and so fell outside the clutches of the prohibition. Mr. Crookenden KC, however, was of the view that this was nonetheless a voluntary assignment because it was the consequence of the voluntary decision of MSI and MBA to enter into the policy. There was then the Section 67 challenge, which was heard almost exactly 12 months ago. And you will have seen, my lords, that the judge found in favour of Dassault, albeit with what she described as an unusual degree of hesitation. Now, we'll obviously be digging deeper into the reasoning of the court at first instance, but it was broadly held that whilst Article 15 did not cover involuntary assignments, a strict view should be taken as to what that meant. It did cover any assignment that the parties had the power to prevent, irrespective of the mechanism of transfer. The judge accepted that whilst there was force in my client's submission that Article 15 should not apply to an assignment to insurers, ultimately the force of that submission had to give way to the court's view as to what the wording of Article 15 provided. So that's how this point arises. Now, to give an overview of our submissions, we respectfully submit that the judge was wrong, and our argument before the court today is going to be as follows. Firstly, we submit that there is a well-established distinction that exists both as a matter of English and EU law between, on the one hand, voluntary assignments or transfers, and on the other hand, transfers or assignments which are involuntary and or occur by operation of law.
You just take that a bit slower, please.
Yes,
A well-established distinction under English and EU law.
and EU law between, on the one hand, a voluntary assignment or transfer, and on the other hand, an assignment or transfer which is involuntary and or which occurs by operation of law.
Which is involuntary and stroke or.
And or by some of the cases, English law cases, we see use the terms in vitam or by operation of law. So there is potentially a distinction between, on the one hand, a transfer by operation of law and a transfer that is involuntary.
What does in vitam mean, really?
Effectively against the will of the other. So there's almost an element of compulsion.
Can we try and use English?
I say in vitam because that's the term that the case...
I know it's the term used 200 years ago in the cases, but we're now in 2023. So we need to understand it, but when we're actually talking, let's try and talk in English so those looking at the live stream know what on earth we're talking about, Mr. Smith.
Against the will of, I believe, my lord, is an appropriate translation.
Good.
Now, we say that that distinction that I've just identified focuses on the mechanism of the transfer itself.
Hang on. This is you are outlining your submissions.
My lord, yes.
And I want to get them down. So
My lord,
you're
yes.
going to have to go slow enough to let me get them down. I know we've got a transcript, but I want to understand them.
My lord, yes.
Yeah.
So
Take it slowly. There's a well-established distinction under English and EU law between voluntary assignment or transfer and assignment, or transfer which is involuntary and or occurs by operation of law.
my lord, yes.
Right. Second submission.
We say that when drawing that distinction, the focus is on the mechanism of transfer itself and not on an investigation into the underlying causes of that transfer.
So focus is on the mechanism of
Transfer and not into the underlying causes thereof, so as to ask in a broad sense whether the transfer is one that has voluntarily occurred. To give an example of that, and I'll be making this good later, a transfer of rights to an insurer via subrogation is treated as an example of an involuntary transfer.
Sorry, say that again.
A transfer of rights to an insurer via the doctrine of subrogation is treated as an example of an involuntary transfer. And that is so, notwithstanding the fact that it only occurs as a result of a series of voluntary acts by the assured.
But you say you've still got to take out an insurance policy and have a payment made under the insurance policy in order to lead to that conclusion.
All of those are voluntary acts. So my learned friend made the point below that this was truly a voluntary assignment because we had a choice to take the policy out, we had a choice to make a claim under the policy, we had a choice to accept payment. But all of those points are true in the context of subrogation. And yet, subrogation is viewed as an involuntary transfer of rights.
As a matter of law.
You said
As a matter of law.
a series of acts by the insurer, but you mean by the insured?
By the insured, yes. Sorry. And if subrogation is involuntary, we say an assignment to an insurer of the kind we're concerned with here must also be regarded as involuntary and or one by operation of law.
Well, you want to be paid by the insurer. Not you, obviously, you are the insurer. But the insured wants to be paid by the insurer. He doesn't care and probably doesn't want the claim to be transferred to the insurer, does he?
Well, I wouldn't necessarily say he doesn't want the claim to be transferred.
That's not what he is seeking to achieve. He's seeking to be paid out.
He's seeking to be paid out so that he doesn't have to bring the claim and recover an indemnity in respect of his or her losses that way.
Yes.
With that groundwork, then, our third point is going to be that the prohibition in this contract applied to assignments or transfers by a party. It is common ground that some meaning must be given to this word by, and what Dassault argues is that Article 15 applies to any transfer that can be fairly said to have been brought about by the relevant party. Paragraph 30 of their skeleton. Now, we say to the contrary that by is intended to reflect the categorization that I have outlined above. The parties were not intending to adopt some form of bespoke categorization of transfers that depends on a factual analysis as to why the transfer occurred. Rather, it is inherently more likely that the parties intended to adopt the categorization that exists at law between voluntary and involuntary transfers along the lines that I have identified. We also say that the commercial factors and consequences support such a conclusion. And most of the arguments we run in this context focus on the position vis-à-vis insurance. And the points we will be making are as follows. Firstly, the terms of the contract oblige the parties to obtain certain specified types of insurance, but without restricting the parties as regards the identity or location of the insurer. But if Dassault is correct, in fact, there was an unspoken limitation in that there would be, if civil law, Japanese law insurance was taken out, a restriction on the usual consequences that would follow of a claim being made against such a policy. We also say the parties would have had a general expectation that each other would have liability insurance of some sort in place. And again, if there were to be restrictions in relation to the usual consequences of having such insurance in place, you would expect them to be spelt out. Thirdly, in this context, we say that Article 15 would not prohibit an insurer from bringing a subrogated claim. And there is no real difference between that scenario and the present one. And because of that, the parties cannot have intended to prohibit the latter scenario, but allow the former.
And your third point, Article 15 wouldn't prohibit a subrogated claim, you mean as a matter of English law?
Correct, my lord, yes.
And it was an English contract.
And it was an English law contract, yes. So with that, those introductory remarks, the structure of these submissions will be as follows. Firstly, I'm going to show you the terms of the contract, reasonably briefly. Secondly, I'm going to address my submission about the distinction between voluntary and involuntary transfers or assignments. Thirdly, I'm going to address the English law approach to the construction of prohibitions against assignment. And fourthly, I'm going to take the court to the exact wording of Article 15. Fifthly, we will be looking at the commercial consequences in the specific context of insurance. Sixthly, and finally, I will be addressing some of the other commercial consequences that the parties have prayed in aid in their skeleton arguments.
So you're not taking us to any of these lovely old authorities?
That is in my third limb of these submissions, the English law approach to the construction of prohibitions against assignment.
And what do you say about those authorities?
What we say, just to give, I guess, a brief spoiler of what those submissions are going to be, is that we accept that there is no bullseye in those authorities that is directly on point. Nonetheless, we would
The judge was right about that.
My lord?
The judge was right about that.
Well, the judge thought the authorities were of very little assistance at all. We do not go as far as that. We say, yes, there is no bullseye which is directly on point, but nonetheless, those authorities do show that A, when construing prohibitions on assignment, the overall approach is to exclude from their ambit assignments which are variously described in the authorities as involuntary, by operation of law, or against the will of the parties, with in vitam being the term they use.
Just say that more slowly. You say those authorities show that when construing prohibitions on assignment, one should exclude what?
Assignments which are variously referred to, we'll show you the terminology when we get onto that section, as involuntary, assignments by operation of law, and assignments which are against the will, or the exact term uses, in vitam.
What's the difference between against the will and involuntary?
I think my learned friend would say that against the will means that there is nothing that the assignor has done to brought about the assignment itself, and indeed positively does not want the assignment. There is an element of compulsion against the assignor, whereas an involuntary assignment could be just one where the assignor is neutral, as it were, as to whether the assignment takes place or not.
Is that distinction relevant here?
It might be relevant, my lord, in the sense that if the court is of the view that Article 15 applies to all assignments save for those which are against the will, namely which MBA positively doesn't want and has done nothing to brought about, then MSI is probably in a bit of trouble on this appeal. But if you construe Article 15 as being somewhat broader than that, as applying to assignments which are involuntary, whether in the sense that the assignor is neutral, or by operation of law, in the sense that it simply occurs by virtue of a statutory or other legal mechanism, but with the assignor in those circumstances potentially being acquiesced.
You said MSI does not want, but what's MSI got to do with Article 15?
I apologise, I misspoke, that should be MBA.
Yeah.
So that's the first point that we're going to seek to draw from those authorities. The second point that we're going to try and rely on the English law authorities is to show that when categorising the relevant assignment, the fact that the conduct of the assignor may have caused the assignment to come about is irrelevant. In none of the cases which we will show you and which were relied on by my learned friend both below and in this court, is there an assignment which takes place as a result of a statute and or by operation of law generally, but which is nonetheless characterised by the courts as being voluntary in nature. And as we will see, indeed, in none of these decisions is there even an investigation by the courts as to whether an assignment by statute ought on the facts properly to be regarded as voluntary. We say these authorities show clearly the court is simply concerned with the mechanism.
There might not have been a case where that had been argued.
In at least two of the cases, a point along those lines was taken. As we'll see, I'll be showing you some, not just the court's decision, but some of the arguments of counsel in those cases.
Okay.
Because there is, in at least two of them, a flavour of an argument very similar to that being made by Dassault in this case.
Okay.
So with that structure in mind, can I first please take you to the terms of the contract, which we can find in the supplementary bundle, tab 1, and the contract starts at page 5. First page I'll take to is page 8. It's a series of recitals in the contract. And those recitals, I draw your attention because they merely make it clear that this contract was concluded against the knowledge and expectation that the aircraft would be on-sold to the Japanese Coast Guard.
So where's that?
That's in the first three paragraphs of the recital.
So they're maritime surveillance aircraft.
My lord, I'm sorry, I didn't catch that.
They're maritime surveillance.
Maritime surveillance aircraft, yes, my lord, yes.
I mean, are they big ones or small ones?
I couldn't tell you anything about the size.
I don't know
my lord.
anything about them. But we
Perhaps
have a
take
picture
instructions
at
on that.
least.
We have specifications, so I can maybe get the answer to that. But this shows that the parties contracted in the knowledge that
Of the subset.
MBA was never going to be the end user of the aircraft, it was selling them on to the JCJ. Now, the question of manufacturing them and having them delivered to the JCJ was in fact a two-stage affair, which is important in terms of the insurance which was required to be in place. If I could just take you to Article 5 on page 16 of the bundle.
I mean, the terms of the subcontract, are they in the papers?
Yes, we have them at tab 2, page 69. They're heavily redacted to remove commercially sensitive information, but the key terms are there.
Subcontract, you say it's at S69, page 69.
Tab 2, page 69, yes.
Okay, we're looking at page 17, did you say?
Page 16, my lord,
16.
sorry. Delivery location. So just to make it clear, and this will explain the relevance of what I'll show you later as the ferry flight insurance.
Yeah.
So the aircraft were first to be delivered at the Mission System Manufacturers Facility in accordance with Article 5.1.1. That was in Waco, Texas. And then 5.1.2, after delivery, the seller, that's Dassault, were to perform a ferry flight to Japan under the buyer's responsibility and risk. So, and what was happening, once the aircraft arrived in Japan, MBA would then perform certain modifications to the aircraft, and then the aircraft as modified would be delivered in Japan to the JCJ. Article 13, please, on page 24. This is the provision which provides for liability for delay under the contract. These are the provisions under which...
So you said page 34.
24, my lord.
24. So,
I beg your pardon, I'm sorry if I misspoke.
yeah.
These are the provisions under which the substantive claim arises. They are not directly relevant because they go to the merits of the underlying claim, but if you look at 13.3, there is a limit. There is a reference to a limit of liability of 100% of the contract price, but then certain matters are carved out of that limit. You see that in the penultimate line of the main paragraph of 13.3. However, such limitation of liability shall not apply in the following cases, and it's product liability claims related to a defective pre-configured aircraft or other defective supply provided in the contract. And then there's B, a claim related to damage to property or bodily injury. And the reason I draw those to your attention, my lords, is that we say these are the type of matters that the parties would have expected the other to obtain insurance in respect of. Parties have their eye on potential liabilities of these sorts arising, and in accordance with ordinary commercial expectations, they would have expected the other to obtain liability insurance in respect thereof. Page 27 is Article 15, the $3.5 million provision that we're concerned about today. That's set out in both parties' skeleton, so I don't intend to go through the wording now, but we'll obviously be doing so later. I should show you on page 29 the Article 20 confidentiality provision. That is a provision which is relied on by Dassault. There are two limbs to the Article 20 confidentiality provision. Article 20.1 applies to disclosure of the contract itself. And there is a prohibition on disclosure that applies to both MBA and to Dassault, with certain exceptions that you can see in little Roman 1 and Roman 2, the contents of which aren't important for present purposes. 20.2 is a further confidentiality provision which applies just to MBA, and it relates to information provided under the contract. There are certain exceptions to that confidentiality obligation in 20.3. It is common ground, and both parties rely on this for different purposes, that there is no mention in Article 20 of any exception for insurance or disclosure to an insurer. We could then go on, please, to page 32, Article 23, in respect of buyer furnished equipment. This is one of the two provisions in the contract which positively obliges one of the parties to take out insurance. In 23.1.5, there is a provision under which Dassault is liable for any loss or damage to buyer furnished equipment. And in the second sentence of this paragraph, they are obliged to take out appropriate insurance policies to cover their liability under this article. We would draw your attention to the fact that there are no limits or restrictions on the type of insurance as regards the identity or geographical location of the insurer. Turning over the page, please, my lords, to paragraph 33 of the bundle, Article 25, the ferry flight. This, as I've shown you, is the flight from Waco, Texas to Japan, which is being performed by the seller Dassault, but at MBA's risk and responsibility. Now, in accordance with the fact that that flight is being carried out at MBA's risk and responsibility, in Article 25.3 of the contract, there is an obligation on the part of MBA to subscribe to all insurances required to insure any kind of damage which could occur in connection with or arising out of the performance of the ferry flight. And in particular, all risk hull insurance up to the value of the aircraft, third-party liability insurance in an amount not less than $250 million US, and certain war and allied risk insurance up to a similar limit. And again, we would draw your attention to the fact, my lords, that there is no restriction as to the identity of the insurer or the geographical location thereof. Those were the terms of the contract that I wanted to draw to the court's attention. I'm now going to move on to the second limb of my submissions, namely the categorisation of voluntary and involuntary assignments / transfers. So we say that there is a recognised distinction in English law between voluntary transfers on the one hand and transfers that take place by operation of law. And to make that good, can I ask you to turn to the authorities bundle, tab 17, where we have Mr. Justice Marcus Smith's book on the law of assignment. And the relevant passage starts on page 186, it's chapter 31.
And Mr. Leslie's book.
And my learned friend Mr. Leslie, co-authored the book.
Which edition is this?
It's the third edition, my lord.
Which page?
Page 186. There's two chapters we have excerpts from. I'll be coming back to chapter 10 in a moment, but it's chapter 31, which starts at page 186, using the page numbers in the bottom right-hand corner. Now, in 3101, the authors make the point, they say, this book is principally concerned with voluntary transfers, that is, assignments or transfers that a party chooses or parties choose to effect. This chapter briefly considers involuntary transfers, that is, assignments or transfers that occur not by virtue of party or party's choice, but by operations of law. And then in 3103, the types of involuntary transfer discussed in this chapter are 1. Subrogation, section B. And then, my lord, if I could invite you to read paragraphs 3104 and 3105 to yourselves, please.
Yeah.
So, 2 points. Firstly, there is no suggestion necessarily here that in the context of subrogation, you look at the underlying factual causes of the subrogation, and if they've been brought about by the transferor, that is said to be a voluntary transfer. And secondly, the term involuntary transfer, the authors make clear, is apt to cover a transfer to insurers via subrogation, and that is a point that they expand on if you turn over a couple of pages, please, to page 189. And again, if I might ask you to just read paragraphs 3111 and 3112, which make good the point that a transfer of rights via subrogation to an insurer is regarded by these authors at least as an involuntary transfer. we say that if subrogation is a species of involuntary transfer, notwithstanding the fact that it arises out of a contract and arises as a result of a series of voluntary acts by the assured, then why equally should not the assignment that occurred in this case also be regarded as an involuntary transfer of rights? Now, whilst we are in Mr. Justice Marcus Smith's book, now's an appropriate moment to deal with a point made by the respondent in their skeleton argument. They say that the distinction we seek to draw between voluntary assignments and assignments by operation of law doesn't work. They say all contractual assignments occur pursuant to section 136 of the Law of Property Act, and so all assignments are in fact by operation of law, even if some of them at least are by contract. Now, in response to this, we have 3 points we would make. Firstly, that is contrary to the categorisation we would immediately note adopted in the Law of Assignments by Mr. Justice Marcus Smith, who does identify a difference between voluntary and involuntary transfers, with involuntary transfers, as I've shown you, being ones by operation of law, and voluntary contractual ones not being by operation of law for these purposes. So Marcus Smith, or Mr. Justice Marcus Smith, I should say, is obviously of the view that contractual assignments are different from assignments by operation of law. Secondly, the premise of the respondent's point in this context is that the right to assign something contractually was created by Section 136 of the Law of Property Act, or its forebear, Judicature Act 1873, such that such assignments are a creature of statute. Now, that is wrong, though, we would submit. If you could just turn now to chapter 10 of this book.
Well, that was legal assignment. There was always equitable assignment.
Quite well.
Yeah.
Quite well. That's the point made by Mr. Justice Marcus Smith at 1003 and also at 1019 and following. 1003 is at page 176 of this bundle, and 1019 is at page 180.
Sorry, you're 1003. You've displeased somebody, Mr. Smith.
The gods are listening.
1003 in this book.
In this book, which is in the same tab,
Yeah.
you go to page 176.
Okay.
And it just simply makes good, my lord, the point that you had already made
Right.
about prior to these statutes, there being a right in equity, at least, to assign contractual rights. As Mr. Justice Marcus Smith...
there was always a tremendously complex set of rules applying to equitable assignments, and the assignee could not sue without joining the assignor. And 136, or the Judicature Act in 1873, simply provided that you could.
My lord, yes, and as Mr. Justice Marcus, or sorry, the authors, I should say, because say in 1003,
Yeah.
what in fact the Law of Property Act is intended to be, and this is the bottom 3 lines of 1003, is a simplification of the equitable rules, provided certain preconditions are met.
It was all about military pensions. The cases were all about military pensions, if I remember rightly.
My lord, yes, so this chapter goes through that history, my lord.
Yeah, great. I used to love it. Yeah.
But anyway, we would say that in circumstances where the Act really, as it says here, simplified the pre-existing rules, it can't be said that contractual assignments are a creature of statute which didn't exist before then. The third point we would make in this regard is if you just turn...
Just explain to me the point against you. I'm sorry, I don't think I've quite understood it. They say that all contractual assignments are under Section 136, so?
So that all assignments, voluntary or involuntary, are assignments by operation of law. Paragraph 28 of their skeleton argument.
I see. maybe a bit simplistic.
Um,
Not something I would expect to say about Mr. Stanley, so I'm sure he'll have an answer to it. Say all assignments, voluntary or involuntary, are assignments to the matter by operation of law.
Yes, because the voluntary ones only occur because of the statute, ergo they are by operation of law.
Yeah, okay.
And the
your third point, yeah.
third point is simply the statute merely provides, the exact wording is that an agreement to assign is effectual in law. We have a statute in tab 12 of the authorities bundle, page 158.
This is 136.
Yes, section 136.
So which page is it?
158 is behind tab 12 of the authorities bundle.
Yes, and all the law was about partial assignments. Because a partial assignment can't take effect under 136. And so you still have the law of equitable assignment valid under applicable to partial assignments.
My lord, yes.
It's all very complicated.
It is a very complicated topic, but
And
you want to...
does the book, Smith and Leslie, does that write about that? Is that, I must look at it. I didn't know anybody had written a book on that great subject.
I'm sure it does, but I'm not in a position to educate the court on what exactly the book says in that regard. Maybe Mr. Leslie can follow Mr. Stanley.
I've been boring my colleagues with my obsession with Chapter 10 of Crossley Baines on personal property, published in the 1960s, which unfortunately was the book I had to use when I was studying this subject at university. I still keep my well-thumbed copy, but unfortunately it doesn't deal with involuntary assignments of shares in action.
Probably one of the reasons it's not in our bundle today.
Yes.
But anyway, the simple point is just that what the statute does is say that a contractual agreement to assign, which previously might have been ineffective, is now effective.
Yeah.
So it's just giving effect to the intention of the parties, but it's not creating the assignment, it's just saying, well, now it will have contractual force.
Yeah.
I've also said, not just that English law, but EU law, and as indeed incorporated into English law via the Rome I regulation, recognises the distinction between voluntary and involuntary assignments of the type we are relying on. And if I could just now turn to that particular point, firstly, just a few tabs on in the authorities bundle, tab 15, page 166, we have the text of the Rome I regulation, and the relevant articles are 14 and 15, which are on page 167. Now, the concepts referred to in Article 14 are familiar, but obviously not an exact match for some of the English law concepts that we use, for obvious reasons, this being an EU regulation. But there is a distinction in Article 14, which covers voluntary assignment and contractual subrogation, and Article 15, which covers legal subrogation. Now, as I'm just going to go on and show you, a subrogation to an insurer that would happen as a matter of English law is something that falls in Article 15. It is regarded by the Rome I regulation as not being a voluntary assignment or a contractual subrogation, but a legal subrogation. Now, just to show you that, if we could turn on to the late Mr. McParlin Casey's book on the Rome I regulation, which we have in tab 16 of the bundle, starting at page 168. At page 170, the author starts his section on legal subrogation. Now, Mr. McParlin goes through the archaeology of Article 15, the Rome I regulations it is. We can firstly see in paragraph 18-106 on page 171 that the forebear of Article 15 was draft Article 17 in the 1972 draft convention. And originally it referred to 4 lines down in this paragraph, transfer of claim by operation of law. And said this title was preferred to the more common statutory subrogation to avoid the problems of classification. The 1972 expert group report indicated that draft Article 17 was intended to cover any transfer of claim arising by operation of law, even if it were classified in domestic law by an expression other than statutory subrogation, such as statutory assignment. So, draft Article 17 then became Article 13 of the Rome Convention, and we see that in the next paragraph, 18107. On Article 13 of the Rome Convention, there is some commentary in the Giuliano Lagarde report, which refers to the scope of Article 13 as involving the substitution of one creditor for another from the assignment of right by operation of law following a payment made by a person other than the debtor. Now, Article 13 of the Convention has now become Article 15 of the regulation, but just if we can just turn on to 18-114, it's said that Article 15 of the Rome 1 regulation reflects the same legislative intent found in Article 13 of the Rome Convention, and the two provisions should be interpreted in a similar way. And then the key bits of this chapter are then over the page. It's 18.115 to 18.116. And it's 18.117 in particular I would draw your Lordship's attention to, where it said, there may be some difficulties in practice in determining which category a particular right of subrogation falls into for the purposes of the regulation, particularly in relation to insurers. Both the 1972 expert group report and the Commission's explanatory memorandum considered an insurer exercising their right of subrogation was an example of legal subrogation. So, pausing there, I'm going to come on to the last sentence in a bit, but it follows, therefore, that the EU Commission and the Rome 1 regulation would regard a subrogation to an insurer as one arising by operation of law, and so in falling under Article 15, rather than a voluntary assignment or a contractual subrogation under Article 14. The author goes on to say in the last sentence, but when an insurer under English law is exercising a right of subrogation by obtaining contractual letter of assignment, this may mean that any choice of law issue falls under Article 14 rather than Article 15. And that's an important point, because that shows that for the purposes, at least of the Rome 1 regulation, you look at the exact mechanism of the assignment when determining whether or not this is an involuntary or legal subrogation or a voluntary or contractual one. The insurer has the insurance policy purely as a creature of contract, and any payment made in transfer of rights occurs because of a series of voluntary choices by an assured. Yet, despite that, for the purposes of Rome 1 at least, whether or not any transfer of rights to the insurer is voluntary or involuntary depends on the exact mechanism by which the insurer obtains those rights. The insurer takes a contractual subrogation or a letter of assignment. We are in Article 14. If it does not, and the transfer occurs by operation of law, we are in Article 15.
And are the consequences different?
The consequences may not, in fact, be different so far as any choice of law, because obviously this regulation is just concerned with choice of law. The point I just make is that obviously when defining, because obviously you can have a different outcome under Article 14 and under Article 15, the line drawn between whether a particular transfer or subrogation falls in one and not the other clearly depends on the mechanism of transfer, with the subrogation to an insurer other than by a contractual letter of subrogation amounting to an involuntary or legal one. But
Are you saying that a contractual letter of assignment would be caught by Article 15?
no. Contractual letter of assignment, if an insurer, as often happens as a matter of English law, for belts and braces reason takes as well an express contractual assignment, then under the Rome 1 regulation, that falls under Article 14.
Forgive me, I meant Clause 15 in this case.
Article 15. that was a point that Mr. Justice Cockerill raised against our argument there. Now, we have two answers to that, my lord. We say we don't have to go that far. The kind of context in which an insurer will obtain rights will ordinarily be either as a matter of automatic subrogation or as a matter of an automatic transfer of rights by statute. It is going to be rare where an insurer needs to take a contractual assignment. And normally, as I say, we'll see that perhaps if we have to look at Lord Hoffman's judgment of the bank financier case, the circumstance in which a contractual assignment or subrogation is taken is just a matter of market practice, as a matter of belt and braces.
Yeah, but what happens if there is one? Does it affect Article 50?
If there was such a one, then what would probably happen under Article 15, at least on our primary case, because we do grasp the net and say
that would be invalid, but the legal assignment would be nonetheless effective.
Exactly. We would say that, so Article 15 would say, no, you cannot rely on your contractual subrogation, but nonetheless you can bring the claim, or at least bring the claim in the name of the assured by virtue of your common law subrogation. So you get to the same outcome in any event. The insurer can bring the claim. It's just one of the two strings to its bow, namely the contractual subrogation, is potentially at least struck down by Article 15 of the sale contract. So the points that we would ask you to take away from the above materials is that there is, we say, an established distinction between voluntary assignments and assignments by operation of law. And we say, when considering whether a particular assignment falls into one or other category, you look at the mechanism by which the transfer occurs rather than the facts preceding that transfer. And that is why, consistent with this, a subrogation to insurers is regarded as a species of involuntary transfer, notwithstanding its contractual and consensual origins.
So you say you never get as far as investigating whether or not the actions of the assured may or may not have brought about the inception of the policy, the claim being made, and that sort of thing.
My Lord, yes. Because even if the assured brought about the assignment by operation of law, that does not invalidate it as being an assignment by operation of law or, in accordance with categorisation, an involuntary assignment. And we go on to say then, when construing Article 15 of the sales contract, it should be construed consistently with this categorisation that exists, rather than, for instance, deciding that the parties, even though they use the word by, which indicates a consideration of whether the assignment was voluntary or not, whether the parties by that word intended to adopt some form of bespoke categorisation of their own, which depends on a factual inquiry. And we say, well, that's unlikely to have been their intention. It's more likely that they would have adopted the well-recognised distinction that already exists in that exact context. Can I now take you on to, this is the third part of our submissions, the English authorities on the construction of prohibition.
So you say, before you get to looking at any authority, look at Article 15 in its context of an English contract, English law contract, a sale contract. This is talking about assignments, voluntary assignments, where you hand over the rights under the contract either to manufacture or to, as it applies to both parties, or to take delivery of aircraft to some third party. And it's not intending to deal with some quite different kind of transfer or assignment which might take place by operation of law, with which every English party is familiar, namely subrogation, and any more to deal with some different legal concept of Japanese law, which is just a different way of doing the same thing. So you just say, well, this is not what the clause is about.
My lord, precisely, yes.
And if it were, it would be pretty uncommercial.
It would be, we would say it would be very uncommercial, and contrary to some of the other terms of the contract, at least sotto voce, in the sense that they require insurance, but without saying, by the way, there has to be English insurance, otherwise your insurer is going to be a bit stuck with not having any rights against us.
Although that's different kinds of insurance. I mean, so they insure the ferry flight. The buyer has to insure the ferry flight, MBA. Let's say the ferry flight goes down, the planes are lost. They make a claim under that insurance. If it's Japanese policy, the insurer can't bring any claim.
Yes, and we say
Same
that
applies. So it's pretty uncommercial policy.
exactly. That's what we say.
Pretty uncommercial contract.
Cannot be the intention of the parties. I'm getting ahead of myself.
Convoluted.
I'm getting ahead of myself slightly, but because we're going to come on to this. But yes, essentially the contract requires MBA to take insurance out in respect of, we've seen third-party liability as a result of something that happens during the ferry flight. So if the plane, because of a defect, crashes on landing during the ferry flight, blows up a hangar, loss of life, so on and so forth, MBA makes a claim against the policy it's been required to take out under Article 25. It is recompensed by its insurers, who then, let's say they're MSI or any other civil law insurer who takes an assignment rather than the English law subrogation. That insurer is then, having identified that the cause of the catastrophe was a defect in the manufacture of the aircraft, going to want to then bring a recourse claim as against Dassault. But according to Dassault, unless that insurance policy is an English law one and provides for subrogation, which falls outside the Article 15 prohibition, the insurer is stuck.
I mean, it's a slightly remote possibility because in this particular case, the buyer is arranging the ferry flight, and so likely to be not have a claim against Dassault, but might have.
Well, it might do, because whilst the ferry flight is at their responsibility and risk, arguably, if the catastrophe I referred to occurred because of a defect in the aircraft, a manufacturing defect, that would be something for which, under the sale contract, Dassault would be liable.
What was the other requirement to insure? Because that was for the seller to insure.
That was for Dassault to insure as regards damage to the buyer's furnished equipment. So the equipment that MBA had to provide put on Dassault's site whilst the aircraft were being constructed.
So seats, say.
Yes.
Say they were building the fuselage and they had to put in seats.
Exactly.
They had to insure the seats. And let's say there was the hangar was kept too hot and the seats were made of plastic and they melted for some reason. And they claim, that's the seller claims, and is paid out by the insurer. The insurer then can't. I mean, I'm just thinking of a situation in which they would.
So if there was
they'd hang themselves.
Yes, if there was a dangerously defective piece of buyer's furnished equipment that was supplied to Dassault's construction yard with that defect in place.
They wanted to claim against MBA, they wouldn't be able to.
Yes.
Because the assignment would.
Unless, again, they've taken out an English law policy.
Yeah.
Allowed for subrogation. And that, we say, is very unlikely to be what the parties intended. But those are the commercial consequences point.
But I mean, your sort of more overarching point, which I think, and I'm not sure it was the point that Lawrence Collins made, but we'll have a look at it, was that this is not what this is about. This clause, Article 15, is about voluntary assignment.
My Lord, yes. And when you come to look at it, and indeed Dassault in its skeleton has adopted various of the justifications given for prohibitions against assignment, none of those apply to this kind of scenario. You have kind of, well, parties want to choose who they deal with. Party want to choose who they might go in dispute with. Those are all the kind of problems that are going to be faced when you have an English law subrogation.
Well, I mean, that requires a focus on what the substance of the contract is, which is building an aeroplane. I mean, if I contract with Dassault, if you contract with Dassault, you want Dassault to build the aeroplane, not Boeing, say.
Yes.
And if they contract to sell it to you, they want you to buy it. They don't want to deal with a difficult buyer in Nicaragua. I mean, I'm taking a country out of the...
No, and my lord, and especially because we know that this contract was concluded specifically with in mind the idea that MBA would then be selling the aircraft on to JCJ.
Yeah.
So it might be surprising in those circumstances if MBA say, well, we've assigned the contract to a third party and the aircraft aren't going to the JCJ at all. Or perhaps that JCJ are interposed in place of MBA and suddenly Dassault find themselves having a direct liability to the Japanese Coast Guard. But those are the potential kind of points, we would say, that a prohibition on assignment, both in this contract and generally, is intended to catch, but not a transfer of rights to an insurer, where all that happens thereafter is that there is a recourse claim for breach, and the only difference, so far as Dassault, or if the boot were on the other for MBA, the only difference to them is the name of the claimant on the request for arbitration.
If your overarching point is right, the English law authorities don't really take you very far unless they were specific to a contract of this kind.
My lord, yes, and I do obviously fairly accept that these are old authorities that deal with a slightly different point. It arises in the context of a lease, and so there are a couple of points that I want to draw to the court's attention because I do think they are relevant and they are consistent with the categorisation that I've already identified. But I do accept that only so far I can go with these authorities. They are not a bullseye, they're not even necessarily a triple 20. They are kind of like helpful, but without kind of being bang on point.
Your overarching point is ground 3. Well, there certainly is a very broad point in ground 3. Is that right?
Well, our overarching point is almost applies to all of them. So the overarching point applies to the general distinction that I've just showed you between voluntary and involuntary transfers. And again, if you're seeking to pigeonhole this transfer, it aligns with the involuntary or by operation of law. I suppose in the sense that the Master of the Rolls has just been putting it to me, it does more fall than just the commercial consequences. And it's the point that Mrs. Justice Cockerill thought was the most compelling point we had, and perhaps why she decided the case against us with an unusual degree of hesitation. Namely, can this be right that if you can have, well, 2 points. One, is a prohibition on assignment intended to deal with this kind of scenario generally? And secondly, can the parties really have intended to say subrogation, that's fine. Any English law insurer or MSI exercising subrogated rights can bring the claim, but an assignment, which is recognised under civil law jurisdictions, which just has the effect of MSI coming out of the open, as it were, and being the name on the request for arbitration, no, the parties didn't want that.
I mean, they accept, do they, that subrogation would be okay? English law policy would work?
There was, before the court, it was floated by my learned friend that this clause might not permit an English law style subrogation. So an insurer might not be able to bring a subrogated claim. So I can show you the relevant paragraph of the judgment. My learned friend, Mr. Stanley, said to the court, well, that is a potential point we could take, but the court doesn't have to decide it. We said, well, no, if you're going to try and take away some of the force of this point that we're arguing by saying, actually, a subrogation could equally be taught, then you have to decide whether or not a subrogation would fall foul of Article 15.
I mean, you're going to show us where you say Mrs. Justice Cockerill went wrong in her reasoning in due course.
My Lord, yes.
Yes. Good. Okay, well, you're on to the point about the English law approach to the construction of non-assignment clauses.
My Lord, yes. And I will try and go through this as quickly as possible, bearing in mind that I do accept that whilst they're of assistance, they're not a bullseye. Firstly, Doe and Carter, tab 1 of the authorities bundle, please.
1798.
1798. One does get a sense of deja vu with some of these cases because the facts are all very similar. They all involve pubs and leases and prohibitions on assignment.
Well, I mean, prohibition on assignment is in the stuff of leases for years. as we now know.
My lord, yes, and that explains why most of the cases, or at least the old cases, do concern leases.
But that is a good commercial reason for not wanting to allow assignment, is that publicans, you want to know the character of the publican.
My lord, yes.
And you don't want the lessee to be some bloke that the publican met in the pub and assigned the lease to on a Saturday night at midnight.
My lord, yes. But equally, even allowing for that strong policy reason, an assignment which is truly by operation of law doesn't fall foul of the assignment. We'll kind of come on to see. There's one of the cases referred to called In Re Rigs, where someone voluntarily petitioned for bankruptcy, got an adjudication against them on the same day, and then as a result, there was an assignment. So that was a series of voluntary acts, and one of the points that was taken, well, hang on a second, that's ripe for abuse if that doesn't get caught by the clause, because someone can just
You can
engineer.
petition for bankruptcy and then get the assignment you wanted, but as an involuntary assignment.
And that, in that situation, in Re Rigs, that was held to be not caught by the prohibition against assignment, notwithstanding the strong policy reasons.
Even that.
Even that. I'll come on to show you that. Doe v. Carter. Doe v. Carter was there was a lease with a covenant not to assign, and what happened was the lessee gave to one of its creditors a warrant of attorney. And pursuant to that warrant of attorney, the creditor entered judgment against the lessee. Judgment was duly entered, and the lease was sold to the defendant.
Hang on, I'm not sure a warrant of attorney to confess judgment.
According to the researches that we've done, a warrant of attorney effectively is a document given to a creditor or potential claimant that allows them to go and enter judgment with the judgment debtor, as it were, not being allowed to stand in their way or reply to the court saying, no, please don't enter judgment. So it doesn't take effect automatically, but it's like almost a blank check that says you can turn up to court and have a judgment entered in your favour. And that's what happened here.
So this was a creditor of the lessor who had the warrant of attorney.
No, creditor of the lessee. So the lessee was the party who was subject to the covenant against assignment.
Yeah.
The lessee provided the warrant of attorney to its creditor. The creditor then used that warrant, entered judgment. Having got judgment, then had the lease transferred to the defendant. The defendant thinks, great, I've got this lease, but then the claimant, who is the lessor in this case, said, no, you can't do that. The assignment to you was prohibited by my contractual covenant.
Yes, I mean, the bit I'm not understanding at the moment is the lessee has a creditor. Well, fine. But how does that creditor get the ability to take an assignment of the lease by simply being given the ability to enter judgment? I mean, he enters judgment for £100 against the lessee. He levies execution on the lease.
Yes, you see that at the first on page 4. It's the first hole punch.
We don't have hole punches.
Oh, sorry, I beg your pardon. It's then a third of the way down, where it says the paragraph starting Brabham entered into possession of the premises. That's the creditor. Possessed them until the entry of the defendants hereafter mentioned. Brabham was the lessee, I beg your pardon. A creditor of Brabham for a just debt took from him a warrant of attorney to confess judgment, upon which a judgment was accordingly entered as of Michaelmas term 1797, execution issued in the same term, and the lease was on the 11th of December 1797 sold under such.
So the lease was sold as a method of enforcement of the judgment.
Yes.
And it was sold with the non-assignment clause, which must have made it of very low value. But no. And then the lessor came along and said, no, you haven't got anything because of the non-assignment clause, which you've known about already.
Yes, and if you look,
They won, did they? I mean, the lessor lost.
The lessor lost. This was held to be an assignment by operation of law, so it fell outside the prohibition, notwithstanding the fact that the origin of the transfer was the voluntary act of the lessee in providing the warrant of attorney to its creditor.
That was the argument that's sidelined.
That's the argument that's sidelined. So what the lessor said, dealing with the cases that said that these covenants don't apply to alienations by law, if you see the sideline, the argument made is the tenant voluntarily executed a warrant of attorney to confess a judgment for him. And unless the landlord can enter for a breach of this condition, it will enable a tenant to do that indirectly and perhaps fraudulently, which he cannot do directly. Now that has a strong flavour of some of the arguments that have been run by Dassault in this case, because they are saying that, well, if the Article 15 prohibition can be circumvented by a party almost manufacturing an assignment by operation of law, that would denude Article 15 of a lot of effect. Now, we don't say that's a good point, but we would note that a very similar argument is made here at the bottom of page 4, that this is a rather convenient way, perhaps, for a lessee to get around a prohibition against assignment. And if you
But I mean, the warrant of attorney to confess judgment, something to confess, to not having encountered before. A warrant of attorney to confess judgment is simply to do with the judgment for the liquidated debt that the tenant owed, right? So the voluntary act was simply saying you can have a judgment against me, effectively. I admit the debt, so you can enter judgment. In our modern language, it would just be perhaps an admission, which allowed you procedurally to get a judgment. But it didn't say anything about the enforcement. It wasn't an admission that you could enforce the judgment, was it? Against my lease.
It wasn't an admission that the judgment could be enforced directly against the lease, but nonetheless, having provided the warrant of attorney, if the monies were not to be repaid, it was almost inevitable that the warrant of attorney was going to be used to enter a judgment.
No, but that's something to do with the lease.
What?
I mean, what I find strange is that enforcements against leases are not very common now, so I've never heard of enforcing judgment against somebody's leasehold interest in certainly not a business tenancy of the kind that a pub would be. I don't think you can't, because the 54 Act makes it a personal right. But so anyway, carry on.
But yes, as I say, but the point is, as I say, an argument was made. Well, if this is right, my lord, I take your point about the purpose behind the warrant of attorney. But the argument was made. Well, hang on a minute. This would be a device that could be used fraudulently, perhaps, to create an assignment or transfer that falls outside the scope of the covenant.
Well, they say it's a just debt, and it's a just debt. So he owed the money. And, I mean, one might owe lots of money and have lots of property, so you wouldn't necessarily expect the just debt becoming a judgment then to be executed against any particular property that the tenant owned. But that's what happened here. Anyway.
Turning on to page 6. The point we draw from this case is, despite the argument being made that I've shown you, so we've got firstly at the top of the page, Lord Kenyon, the Chief Justice judgment, and you'll see from the tramline, the first of the two tramline passages, that Lord Kenyon adopted, says, I adopt the distinction relied upon by the Defence Counsel between those acts that the party does voluntary and those that pass in vitam. Judgments in contemplation of law always pass in vitam, and I see no difference between a judgment that's obtained in consequence of an act resisted and a judgment that's signed under a warrant of attorney, since the latter is merely to shorten the process and to lessen the expense of the proceedings. Well, that's true, but it's still a voluntary act, we would say.
Well, I mean, it's the point. He makes the point I've just made.
Yes, my lord.
and non constat, that it would be followed up by the term being taken in execution under that judgment.
Yes, my lord.
So,
And
so he says, I agreed to enter. You agreed to enter the judgment. That's anyway not a voluntary act, because the judgment is always involuntary, even if you've short-circuited the procedural process. But it didn't follow that you expected them to take the lease in execution.
well, my lord, where I would respectfully differ from that is that it didn't follow that they didn't expect you to take the lease in execution. We would submit that whilst the warrant of attorney may not have directly referred to the lease, it could have been reasonably expected that A, judgment would be entered, and B, that judgment would then be enforced against the lessee's assets, one of which was the lease. Mr. Justice Gross, towards the bottom of the page, makes a very similar point, my lord, to your one. Again, this is the second of the tramline passages, where he makes the point that the words in this covenant rather point to some act to be done by the tenant himself, but the giving of a warrant of attorney did not specifically operate on this property. And we would perhaps say that
I
analogy.
mean, that's an exceptionally good point.
Yes.
Is it not? I mean, that was the point I've been making since we started.
My lord, yes. And we would just say that it's analogous. There was nothing in the insurance policy between MBA and MSI that specifically said there will be an assignment operating specifically on this contract.
I mean, it was a bit of a long shot argument, wasn't it? Because the argument was that you'd given the warrant of now we understand, you'd given the warrant of authority, and therefore you actually set a train of events, a bit like dominoes, which ended in this involuntary assignment. But actually, obviously you didn't. It might have been enforced against your horse and cart.
My lord, yes. And the simple point we seek to draw from this authority is that there's no suggestion in the judgments that actually there is any relevant question of inquiring into the facts and seeing whether or not the lessee set the chain of dominoes in motion himself deliberately.
Well, there is a bit.
Yeah, there is some.
I mean, there is a bit, because he says the lead judge, whatever he was, I assume it was he in those days, did say that having agreed to the warrant of authority, it didn't follow. You know, I read it out, non constat. Doesn't follow that he was going to enforce against his property. So he was sort of inquiring into whether.
But it said that the warrant didn't specifically refer to the property. That's the point that being made. The warrant didn't specifically operate on the
No,
property.
of course it didn't. Anyway, there we are. I mean, it's a great case. I've enjoyed that, Mr. Smith. Whether it helps us or not, I don't know.
Well, my lord, Doe and Bevan in the next tab.
Yeah. Good Beher in Bevan. Marvellous name.
Yes, and the owner of a pub.
Yes.
Doe and Bevan, I will be hopefully even briefer on. There was a lease of a pub to a Mr. Shaw. That lease contained a covenant that neither he nor his assigns would assign the lease without consent. The lease was then deposited with a creditor of Mr. Shaw's as security.
Yeah.
Mr. Shaw became bankrupt, and the lease was then assigned to a third party. We don't actually know who the third party is. There's just reference to the lease in the first instance being assigned to one of Mr. Shaw's assignees. But then that third party assignee sold on the lease to the defendant. So this was a two assignment or a two transfer case. One in the first instance that followed by Mr. Shaw's bankruptcy to his assignees, presumably a trustee in bankruptcy.
Yes,
And
assignee in those days.
yes, and then on to the defendant. Now, all I rely on, and as I say, it is of some assistance, but I accept it doesn't take us too far. There was no question raised of any sort as to whether or not the first assignment to the assignees was prohibited by the covenant against assignment, and whether or not there needed to be a factual inquiry into the circumstances in which that assignment had occurred, to see if the original lessor had somehow brought it about by their voluntary acts. It was accepted by all concerned that that first assignment did not fall foul of the prohibition. And you can see that most clearly from Mr. Justice LeBlanc on page 10. And it's the final of the 3 tram lines on the side. It's just at the very top of that. It is clear there has been no assignment by the lessee himself. It's also clear that the lessee is becoming bankrupt is not a breach. So, and what we would say Mr. Justice LeBlanc is saying there is that there's no assignment in breach of the covenant by the lessee himself. So, again, I accept it's a minor point, but the lack of any curiosity or inquiry as to the circumstances of the first assignment and whether they were brought about by the lessee, we say, is helpful to us. Moving on to a case that's been relied on by Dassault and indeed by Mrs. Justice Cockerill as being against my client is In re Birkbeck in tab 4, starting at page 40. Sorry, it's not re Birkbeck, it's Cohen, tab 5, I beg your pardon. It's the case that Dassault and Mrs. Justice Cockerill thought was against my client.
Is this also at page 40?
Page 46, tab 5, page 46, I beg your pardon. Bad reference. This case concerned a lease with a covenant not to assign without consent. Now, there were 2 initial assignments which were consented to, so that they can be part, so to speak. The new lessee was a company, and in June 2016, the shareholders passed a resolution for its voluntary winding up. The liquidator then assigned the lease, and the lessor sought to challenge this assignment. Now, if you turn on to page 47, you can see the arguments.
Who challenged it? The shareholders?
No, the lessor
lessor
sought to challenge the assignment.
Yeah, okay. Which page?
Page 47. So just you can see here the argument of the liquidator, where the liquidator argues, it's Mr. Cunliffe, Casey, and Mr. Frampton. A covenant not to assign has reference to assignments by the act of the party, but not to assignments by operation of law, Doe v. Bevan. Therefore, an assignment by a liquidator of a company which is being wound up compulsorily is not a breach of the covenant. And one of the cases relied on, we'll look at it in a minute, in Riggs. And then the argument is it should follow that an assignment by a liquidator in a voluntary winding up, which is analogous to an adjudication in bankruptcy on the debtor's petition, is not a breach of the covenant. Now, one critical point to understanding the decision in Cohen is that there was no assignment of any sort to the liquidator. The liquidator was exercising the company's powers in its own name. Now, you can see that. I don't know if that's controversial. I'll give you the reference, and if needs be, I can take to a reply if it is controversial. But from one of the other authorities in this bundle, In re Farrow's Bank, which is at tab 6, page 52. And
this is because it was a voluntary liquidation, members' voluntary liquidation.
Well, whether compulsory, as In re Farrow shows, whether compulsory or voluntary, the powers of a liquidator were ones to do acts in the name of the company.
Indeed.
So the liquidator is not an assignee. There is no assignment in Cohen by operation of law. And that is a critical point, we say, to understanding of why this case and why it's not against my clients.
I mean, you have to look at the Companies Act, because which year we're in 1917, so we're probably looking at the 1873 Companies Act.
And if you would like, my Lord, chapter reversing that, I wasn't intending to take you, but you have at page 61 of this bundle from the Master of the Rolls, Lord Sterndale, in the In re Farrow's Bank case, a discussion of the relevant provisions of it's the Companies Consolidation Act 1908.
Yes, that's right.
Which make it clear, and if you, I say, pages 61 to 62, just for your note, that a liquidator, whether under a compulsory or a voluntary liquidation, it is exercising its powers in the name of the company. There is no transfer or assignment of rights to it.
Yes, so it's exactly to bring or defend any action or the legal proceeding in the name and on behalf of the company.
My lord, yeah.
But that was a compulsory liquidation in Farrow's Bank. And
Yes.
This was a member's voluntary. Is that the same?
Yeah,
I don't
yes.
think it is, because that section. I used to know about these things. I'm not sure I do now, but I think there's a distinction between how the liquidator acts under Schedule 4 of the Insolvency Act in a compulsory liquidation and in a voluntary liquidation. I think that historically goes back to the 1873 Companies Act. So can you show me in Cohen where the power of the liquidator, where it says that he acted in his own name?
It doesn't say that in Cohen. The reason why I've had to show you the law as set out in Free Farrow's Bank, which refers to both the position in compulsory liquidation and also towards the bottom 61, there's reference to a voluntary liquidation.
Where does it say in Cohen that it was a member's voluntary?
Page 48, you can see at the start of Mr. Justice Rolat's judgment.
Because Mr. Justice Rolat did know about these things. This is an action brought against the company in voluntary liquidation, breach of the covenants of the lease.
Now, the
I
point
mean, he says they are assignees.
No, my lord. He says the defendant, so the liquidator, assigned the lease to the defendants. And in line 3, the defendants are themselves assignees of the lease. So my point is that from the lessee, there was no transfer of rights or assignment at all to the liquidator.
No.
The liquidator then assigned the lease to a third party to the defendant. And the question was whether that assignment was in breach of the covenant against assignments. And it was held, because it was an act of the company, it fell within the prohibition. And my point is, obviously one of the points we make is that when looking at a statutory assignment by operation of law, you don't look to see the facts underlying that which caused that assignment to come about. Now, Cohen is said to be a case against me in that regard, but the key is it's not, because there was no assignment by operation of law in Cohen. And therefore there was no consideration at all in Cohen of whether an assignment by operation of law...
So it was the voluntary act of the liquidator in assigning to the lady without means that you say was the assignment that they said was a breach of covenant.
Yes.
Simple as that.
Simple as that. Simple as that. It was effectively an assignment of the company.
Yeah.
It was an assignment of the lessee, because the liquidator was simply acting in the company's name.
Whereas in the great case of, or both the great cases of Good Bahia and the other one, there was an assignment by operation of law.
Yes.
When the lease was executed upon.
Yes. And so it cannot be said that Cohen is authority for the fact that when there is nonetheless a statutory assignment, it can be regarded as voluntary if you look at the facts and how it's been brought about, because there was no such assignment in that case. One of the authorities considered on page 49, I referred you earlier to In Re Riggs.
Yeah.
You can see that's the judgment of Mr. Justice Wright, and that's dealt with at page 49. It said, 5 lines from the top, in that case, in other words, in Re Riggs, a lease of a house contained a covenant not to assign and a proviso for re-entry in case the lessee should file any petition under the bankruptcy laws. The lessee filed a petition in bankruptcy upon which he was adjudicated bankrupt, and the lessor purported to determine the lease under the proviso for re-entry. Mr. Justice Wright held the re-entry was bad. Then came the question of whether the bankruptcy was a breach of the covenant not to assign. The learned judge said, on the construction of this lease and apart from authority, I should be of the opinion that in this covenant the words assign or underlet are used in their ordinary and popular sense and refer only to such assignments as made directly by the lessee, as distinguished from such assignments by law as a result by the statute from a petition in bankruptcy followed by adjudication. So in re Wright is actually the case which is more similar to this one, because what actually happened is the lessee filed a petition in bankruptcy, a voluntary act. He was adjudicated a bankrupt, and that triggered, those voluntary acts triggered the statutory assignment. So there was an assignment by operation of law in re Wright, in re Riggs, but that was held not to fall foul of a covenant against assignment. And what Mr. Justice Rowlett does here, he didn't demur or suggest that he thinks in re Riggs is wrong. He just makes the point, you can see over the page on 50, that in the context of a voluntary liquidation, the liquidator is acting merely as an agent, or could be acting as an agent for reconstructing the company on a sounder basis. And the company whose liquidator in such circumstances assigned an onerous lease to a magistrate could not to be heard to say the assignment had taken place by operation of law and not by its own voluntary act. There is no essential difference between such an assignment and that of the present case. If the former is tinged with the taint of voluntariness, so is the latter. But again, that's not referring to any assignment by operation of law. It's referring to a liquidator who's been put in place by a voluntary liquidation motion, then looking in the company's name to assign to a third party. And you say, well, that's a voluntary act. And the very simple reason why it's a voluntary act is because it's in the name of the company. But what Mr. Justice Rowlett is not doing, saying that, is saying that you can take an assignment by operation of law or statutory assignment and treat it as being voluntary because the assignor has brought it about. That was the In re Riggs case, if there was a point to be made in that regard. The final one of the English author...
I mean, it's not a brilliant... The last sentence is not really right, I think. He says, I think there's all the difference between an adjudication of bankruptcy and a voluntary winding up. I don't think that's the distinction he's drawing. He's drawing the distinction between an assignment caused by the bankruptcy and an assignment by the voluntary will of the liquidator.
Yes, ma'am. And it's the former which is analogous to the facts of our case, and the latter isn't.
Yeah, well, I mean, I get that. Okay. Good.
Final one of the English authorities is in a different context, which we're pleased to hear. No more pubs. It's Hay we're concerned with in tab 8, Thomas and National Farmers Union Mutual Insurance Society, a decision of Mr. Justice Ditlock. Tab 8, page 76. This was there was a tenant of a farm who gave a notice to quit and left behind some hay and some straw. The hay and straw were insured under a policy which stated that the policy would cease to be enforced if property passed from the insured to any other person other than by operation of law. Now, the tenant asked the insurance company to keep the hay and the straw insured in the meantime. They agreed. The hay and straw was then destroyed by fire, and the tenant made a claim under the policy. Now, as a matter of law pursuant to the Agricultural Holdings Act 1948, the effect of the 21, Mr. Justice Ditlock goes through the provisions of the Agricultural Act in some detail.
And the word crops is held to include hay and straw?
My Lord, yes, please.
These cases are wonderful, aren't they?
Yeah. And if you go to page 81, please, I wouldn't ask you to consider in detail Mr. Justice Ditlock's doubtless very learned analysis of the Agricultural Holdings Act.
81.
But in 81, if you see the paragraph starting those being the relevant sections of the Act, it refers to submission 4 lines down. On quitting the holding, the property in the hay and straw is divested from the tenant to the landlord, and in its place the tenant is given the right to obtain from his landlord compensation for the hay and the straw. And Mr. Justice Diplock says, it seems to me quite clear that at some point, either on or after the tenant quitting the holding, the property, which he undoubtedly had before that date, is divested from him and vested in the landlord. So you've got a transfer, and the insurers therefore say, and you see this over the page at 82, that this was nonetheless not a transfer by operation of law, and their argument is very similar to one of the arguments being made by Dassault here. And
Because they'd entered into they'd voluntarily left the property, given up the tenancy, whatever.
Yes, and because, and the specific point made here, those are points precisely, my lord, you look in the tram line, the argument was, it cannot be said that the passing of the property is by operation of law because the landlord and the tenant could have made an agreement to the contrary. About halfway down the tram line, and that was dismissed. Mr. Justice Diplock says, I do not think that is a sound argument, and it does not seem to me to affect the meaning of the expression operation of law, where property passes automatically as a result of statutory provisions when certain circumstances arise. It seems to me there is a passing of property by operation of law. So those are the English authorities, my lords, and we would ask you to take from them the following points. Firstly, we say that, generally speaking, a prohibition on assignment will not be construed as applying to assignments by operation of law. You look at the terminology in the cases, some of them refer to assignments by operation of law as being synonymous with involuntary assignments. It's also true that some of them use the expression in vitam or against the will. Secondly, we say there is...
What did the judge say?
Sorry?
What did the judge say about these authorities? I mean, I'm afraid I skipped over the quotes. She quoted a lot of this stuff that we've just been looking at. She said it didn't amount to beans.
Didn't amount to road beans, if anything, because of, say, the reference in Re Cohen to the taint of voluntariness, if any, and the references to certain assignments being in vitam, against the will. Mrs. Justice Cockerill was of the view that if a line can be drawn from these authorities, it was against my client in the sense that it suggests that the touchstone is whether there is a taint of voluntariness or not in the assignment.
That you say that misses the point.
We say that misses the point, because there is not a single one of these cases in which there has been an assignment by operation of law, and yet the court has thought it fit or appropriate to determine whether that assignment was indeed truly voluntary by analysing the circumstances leading up to that. Cohen, contra to Dassault's arguments, is not an assignment for that authority for that proposition at all, because, as I've said, there was no assignment by operation of law.
Well, I mean, all you really get out of this is that there isn't a need under these cases to investigate whether an assignment by operation of law is given rise to as a result of a series of voluntary acts, provided it is an assignment by operation of law, which is of a different quality and different character from a voluntary assignment.
My Lord, yes.
And that's all you get. Really.
That's all we get. So, Doe v. Carter, there's the irrelevance of the warrant of attorney. In Re Riggs, there's the irrelevance of the fact it was a voluntary petition for bankruptcy. And to Thomas, it's irrelevant the fact that the tenant quit the property and could have made different arrangements. I
mean, much as I would love to have an interesting discussion with you about the difference between a member's voluntary liquidation in 1908 as against 1873, that really isn't relevant, because they were only invented around that time, members' voluntary liquidations. But none of that matters at all, because it's just what I put to you. Your submission is there isn't any body of law that says you look to see what gave rise to the assignment by operation of law. If it's an assignment by operation of law, that's what it is. That's of a different quality to a voluntary assignment. There you are.
My Lord, yes.
And that this clause is about voluntary assignments, not about assignments by operation of law. That's your case.
Precisely so, my Lord.
Right, simple.
Yes. Next section, the wording, which we can take reasonably briefly because it simply turns on one word, by. I've shown you obviously the term of the contract in the supplementary bundle. You have Article 15 cited in both parties' skeleton arguments, my Lord. If you wish to look at it in the contract itself, it's a supplementary bundle, page 27, tab 1. Yeah, I mean, there are various points made both in the skeleton argument of Dassault and also in the judgment below about the width of Article 15. But we say that those points are irrelevant. They have no bearing on the issue the court has to consider because Article 15 only applies to an assignment by a party. If the relevant assignment is not by a party, it doesn't matter how broad the surrounding bits and pieces of the prohibition is, the assignment is not caught. Now, it follows that what...
You say it would have to say brought about by any action of any kind in the fullness of eternity.
My Lord, yes.
But it doesn't. It just says an action by any party.
Exactly.
Yeah.
And
Although it does say for any reason whatever.
it does say what... So, but all that means
So
is...
that's so you have to hang your hat on by
Yes.
because for any reason whatsoever is against you.
If it is...
If by doesn't mean what you say.
My Lord, yes. If by doesn't mean what I say, then MSI is in some difficulty. They can't say, even if it was an assignment by MBA, it was for an acceptable reason, because those words you've identified, my Lord, are very much against me in that regard. Now...
But I mean, for any reason whatever, it doesn't matter at all if by a party means what it says.
Yes, my Lord, yes.
Yeah.
And we've said in our skeleton argument that Dassault's construction requires a gloss to be put on by. We've said by or caused by. My Lord Master of the Rolls has suggested another gloss would work, but the key to it is it requires some gloss, some wording of that sort to bring in with the scope of the prohibition an assignment of this sort.
Yeah, and you say you shouldn't. You should construe the words as they are, and if they don't have an ambiguous meaning, then you move on.
Precisely, my Lord, and especially so, bearing in mind if the court's obviously with me on the point I made earlier about there being already an established categorisation between, on the one hand, voluntary transfers, on the other hand, involuntary or by operation of law, with the decision as to into which category you fall being determined by the mechanism of transfer. If you accept my submissions on that point, then we say that for that further reason, by should be construed consistently with that. You look at the mechanism of transfer.
You might not even need that.
I
mean,
it's
you're
a second
reading an
argument.
awful lot into the construction of a contract, to say that those drafting it have full knowledge of fine legal distinctions.
My Lord, I take the point, but at the same time, if there is, as a matter of English law, that distinction that exists, to be against MSI, the court would have to find that the parties intended to adopt their own bespoke and different categorisation that involved a factual analysis. Now, in circumstances where English law provides you with a ready-made categorisation, we say that that's unlikely. But that's as far as we take the point. Okay. That's all I have to say on the wording and by commercial consequences. And this section deals with commercial consequences in the particular context of insurance. My Lords, you will doubtless recall from paragraph 36 of Mrs. Justice Cockerill's judgment that she said that instinctively her feeling was that a transfer to an insurer should not be caught, and she cited a passage from Clark on the law of insurance contracts, which was to similar effect. And we would respectfully suggest that those instincts were correct. The effect of Dassault's construction of Article 15 is that whilst an English law style subrogation is permitted, such that MSI could bring a claim, albeit in MBA's name, an assignment of rights to MSI to allow it to bring that same claim in its own name is prohibited. Now, that's the consequence of Dassault's argument, and we say that cannot be right for various reasons. The first reason, there is no difference of any substance between the two scenarios, namely MSI bringing a claim in its own name or MSI being a subrogated claim in MBA's name. If there had been a subrogation in the English law sense to MSI, MSI would nonetheless still have been instructing the lawyers, Norton Rose Fulbright. MSI would be controlling the arbitration. MSI would be authorising the key decisions in the arbitration. And if there was to be a settlement of that arbitration, the negotiating parties would be Dassault and MSI. And the only difference between that scenario and the present one is the name on the request for arbitration. And we say that unless Dassault can come up with a convincing reason why the parties would have wanted to allow one scenario and prohibit the other scenario, it is inherently unlikely that they intended to draw a distinction between the two. Now, we say that this knocks away various of the commercial justifications for the Article 15 prohibition given by Dassault. And these are all laid out in paragraph 18 of their skeleton argument. And I've touched on these briefly, so I don't need to go. They refer to multiplying the number of people involved, making dispute resolution more complicated, commercial parties wanting to deal with parties they know and trust. Well, these are all problems that they're going to have to face if there's an English law subrogation. They say we don't want to deal with a hard-nosed insurer, but you're faced with that anyway if there's a subrogation to an insurer. So it's not a reason to hold an assignment to an insurer as falling outside.
I'm right in thinking that MBA and MIS are commercially unconnected.
That's my understanding, my lord, yes.
In fact, on
MIC.
that point, potentially, it goes the other way, doesn't it? Because if you've got a subrogated claim, you sometimes have tension between the insurer and the insured, which if you're the party on the other end, that can sometimes adversely affect the litigation. I mean, worst case scenario, the insurer pays out the insured. But you can sometimes have tension, which doesn't help the other party. Whereas if you've got the insured as the party, then there's no potential for conflict.
I take the point, my lord. I think it's perhaps not quite so straightforward as that. The kind of tension that arises of the sort you've mentioned can be perhaps where the assured has certain uninsured losses that it also wishes to have a claim for.
Yeah.
And so there's a diversion of interest. But that's a scenario that's equally capable of arising under a civil law insurance policy where there is an assignment of rights. So the assignment of rights will be in respect of recourse as regards the insurance sums paid out, but it wouldn't necessarily prohibit the assured from bringing a claim for its uninsured losses under the contract. So that tension would still exist, we would respectfully submit, even in in both scenarios.
Yeah.
Another point made by Dassault is regards confidentiality, but as again we say that that's a risk that exists anyway in the context of subrogation, and besides which duties of confidentiality are not absolute. Now, Dassault have sought to give two answers to this point. There's firstly a point that was made by the judge below, paragraph 50.1 of their skeleton argument, and they say that subrogation and assignment are different concepts in law. And that may be true, but so far as these parties are concerned, so far as Article 15 is concerned, there is no difference in substance or practice between an insurer bringing a subrogated claim and an insurer bringing a claim qua assignee. For this to be a good point, we would say the court has to conclude that the parties had the distinction between subrogation and assignment in mind and had some particular reason based on the difference between those two concepts for wanting to allow one and prohibit the other. But there's never been any attempt by Dassault to identify why subrogation is okay but assignment's not.
Well, this is the furthest reaches of contractual interpretation, really, isn't it? I mean, what the parties might have had in mind when they negotiated a contract is really only relevant if the words are truly ambiguous.
My lord, yes. And we say
you say they're not ambiguous.
they're not ambiguous. Right.
So you say that we don't even get to looking at factual matrix.
My lord, yes.
I mean, we look at basic factual matrix, we don't get to looking at any really commercial factors because there's no ambiguity in the words used.
There's no ambiguity in the words used. But at this point, arguing about different legal concepts are unlikely to be the kind of matters in the party's mind unless it made some substantial or practical difference to their position. So, we would accept that if my learned friend could point to a significant practical difference, why that might justify it. But absent such a difference, simply saying, well, they're not the same concept, we would respectfully agree that that's not like the kind of thing the party would have had in mind and is to be taken into account when construing Article 15. Also in Dassault's skeleton, in paragraph 50.2 of that, again, they float the possibility of an argument that subrogation might indeed be treated as a transfer of rights, so as in itself to fall foul of the Article 15 prohibition. So as a way to try and neuter my commercial consequences point, they say, well, it's not right that subrogation is allowed and assignment isn't. Subrogation might need to be allowed. Now, as to this, we say that Dassault, if it wanted to take this point, needed to grasp the nettle, issue a respondent's notice, which said the court was also right for the following reason, namely a subrogation would be prohibited by the clause, and then we would be having full argument on that point. What they can't do is effectively repeat what they did before Mrs. Justice Cockerill, which she rejected, is merely float the possibility before you, but without fully committing to the point. Just as a small point, it's a slightly interiorum point, but we would suggest that the insurance market would view with some disquiet any suggestion that a prohibition on assignment or transfers would prevent an insurer from exercising subrogated rights. And it's doubtless because of the concerns that would be raised if such an argument would be run, and the difficulties with such an argument, that Dassault are merely mentioning it as a possibility rather than positively arguing.
When you say the judge addressed this, is this the point at paragraph 102 of her judgment? Mr. Smith, rightly in my judgment, says it would be wrong to take into account Dassault's favour an asserted potential problem without deciding these provisions of subrogation would in some cases fall foul. That's the point.
That's the point, and in 104 she decides that therefore Dassault's case should stand or fall on the basis that subrogation would not fall foul of Article 15. So that's our first point of commercial consequences. There's no difference between subrogation and assignment in this context, so parties can have intended to prohibit an assignment. Our second point is that Dassault's argument has the effect of hindering the parties' access to the insurance market. Now, these are points I've touched on already. You have my example of the position as regards the ferry flight insurance. And the very real possibility of, in the event of a defect in the aircraft, a claim being made against Dassault pursuant to the obligatory insurance that MBA had to obtain. Now, we say that it cannot be right that if MBA had taken out ferry flight insurance with MSI or any other Japanese insurer and the catastrophe occurred, that insurer would be prohibited from bringing a recovery claim against Dassault. If the parties had intended that, they would have included express restrictions on the type of insurance to be obtained in this regard. And this was also what the judge described almost slightly as a comity point. It's not comity in the strict sense, but we would say it takes a somewhat insular or maybe parochial view for the contract to be construed in such a way as to require MBA, a Japanese company, to take out English law insurance or else risk being worse off as a result of it.
Do the provisions in relation to ferry flighting permit recourse against the seller? In 25.3 requires that the buyer shall insure, including on the seller's behalf. I'd have thought that might be construed as ruling out a right of recourse against the seller.
we would suggest that if, due to a defect in the aircraft, there was a catastrophic accident with several $100 million of loss, it were to be suggested by Dassault that the effect of 25(3) is effectively to exclude any liability on their part because they were to be a party or to have the benefit of the ferry flight insurance. I would suggest that argument would face an uphill battle. It's not phrased as an exclusion of liability. At the very least, there would have to be an argument that...
No, but the buyer would have had to obtain insurance on the seller's behalf, wouldn't they? So it would be rather circular.
But the effect of that...
against the seller.
The effect of that would be, let's say, the scenario that we posit is there's the accident or catastrophe in Japan on landing of the plane in the ferry flight, and that MBA is the local Japanese party, the one who is held liable. It's their premises; they're the ones who are held liable, and therefore they have a kind of like substantive liability. So they're the ones who make a claim on their policy against MSI or any other Japanese insurer. And then there's a question of, well, this was due to a defect in the aircraft. We shouldn't have to be picking up the tab for that. And in those circumstances, we say that it's clear that MBA, whether in their own name or MBA's insurer, would want to bring a claim for that defect against Dassault. And any suggestion that such a claim would be precluded simply because Dassault was to have the benefit of insurance in 25.3, we say that would not be a good argument. It's not phrased as an exclusion of liability. All it says is, effectively, if the claim perhaps in the first instance was made against Dassault, Dassault can then perhaps have recourse to the relevant insurance. But if the claim in the first instance is made against MBA, then it would necessarily follow that MBA, if there was a defect in the aircraft for which Dassault were responsible, could bring a recourse claim. And if that's right, its insurer must also be entitled to bring such a recourse claim. So that's what we say about the ferry flight insurance and access to the market. And you also have my point that it's not just the ferry flight insurance the parties would have expected. These aircraft are capable of causing massive loss of life and damage to property. You see a reference in 13.3 to product liability insurance. There is no evidence before the court as to what form of liability insurance the parties had out. So we only put the point like this. Both Dassault and MBA would have ordinarily expected the other to have obtained some form of product or third-party liability insurance which protected them against defects, either with the aircraft as constructed by Dassault or the aircraft as modified by MBA. And in light of that expectation, if there was to be a restriction on the consequences of a claim being made on that insurance, you would expect that to be spelt out in the terms of the contract. Now, one answer that is made to some of these points is that MBA could have sought Dassault's consent before entering into the relevant insurance, because Article 15 does allow assignments or transfers if they are obtained with the consent of Dassault, or either party for that matter. Now, we say that the consent mechanism does not work in this context, in the context of insurance policy. The first point we would make in this regard is, well, if this is a workable solution to the problem we've identified, when should MBA or Dassault seek consent? Well, the one option given by Dassault in their skeleton is seek consent before the relevant insurance policy is entered into. But we say that goes beyond the wording of Article 15. That would not be necessarily seeking consent to an assignment or transfer, but seeking consent to an insurance policy, which might, in a series of eventualities down the line, lead to an assignment. Even Dassault, in their skeleton argument, paragraph 34.1, accept that the consent that would need to be sought in this circumstance is to a general consent to any transfers that might arise. And it's not easy to read Article 15 as implying in this manner. And we would say that if actually MBA had gone to Dassault and sought their consent to any transfer that might arise under the policy, it's like they would be told, well, no, we don't have to answer this at the moment. We have to give you a consent to an assignment, not to any assignment that generally might arise in the future. So come back later. And if that's right, then that would leave the requesting party in an invidious position where they don't know if they can enter into the insurance or not, because consent to the consequences several steps down the line hasn't been given. And we also say, as regards the question of whether we should seek consent before concluding the policy, that's commercially slightly unreal, giving one party the right to veto or kind of dictate the terms of the other's own personal insurance policies.
I mean, this is one of the furthest reaches of the arguments, perhaps something to deal with in reply.
Well, yes. Just to deal with a few other of Dassault's responses to our commercial consequences in the context of insurance point, 50.4 of the skeleton, they ask, how as a matter of construction do you get to this outcome? We simply say by reference to the word by. It's really as simple as that. You don't require any sort of implicit limitation to be read into it. Transfer of rights by subrogation is involuntary and therefore would not be by. So why should a transfer of rights by an assignment also not be one by a party? So linguistically, there is really no difficulty here in fitting our construction into Article 15. One point the judge made, and it's a point again we've addressed earlier, so I probably don't need to deal with it at any real length, is it was suggested that a difficulty with our argument was that it must apply to all assignments to an insurer. Voluntary, genuinely voluntary and contractual ones, as well as involuntary ones. And it was said that assignments of the latter sort can't be brought within the wording of Article 15, and as a result, our argument falls apart somewhat. Now, I've dealt with that to a certain extent already, and our answer is very simple. You don't need, an insurer doesn't need to take a voluntary or contractual assignment because it will either have a right of subrogation arising at law, or in Japanese law, and indeed this is reflected by a lot of civil systems, an assignment by operation of law. Now, Dassault hasn't identified a relevant system of law under which an insurer can only gain recourse claims by taking a voluntary assignment, which might leave a lacuna in this article. So we say we don't need to go as far as to show that Article 15 would not prohibit a voluntary assignment to an insurer. And as I made the point in answer, I think, to Lord Justice Phillips, if you do have an insurer who both has an assignment at law or subrogation at law and then belt and braces takes a contractual one or the other, the contractual one might be struck down, but the outcome's the same because they can just rely on their rights at law. Final section are other commercial consequences. This is just going to sweep up very briefly a few of the other points made by the parties as regards the commercial consequences of the competing constructions. We say that one consequence of Dassault's argument is that it enlarges the scope and possibility for disputes and creates uncertainty as regards the operations of clauses such as this. If a prohibition against assignment or transfer only bites on voluntary assignments, and in order to decide whether an assignment is voluntary or involuntary or not, you just simply look at the mechanism of transfer. That is very simple and straightforward. The parties will know which assignments will be caught, which won't, and there's little room for argument. However, on Dassault's case, there will need to be an investigation into the circumstances of the assignment. The judge said that Article 15 caught assignments that it was in the assignal's power to prevent. Well, on that formulation, nearly every assignment by operation of law might be said to have been within the power of the assignee to prevent, sorry, the assignor to prevent. And therefore, if you take this to its logical conclusion, it somewhat destroys, or at least allies, the distinction that does exist between voluntary and involuntary assignments, and creates various difficult questions. What about where a party is obliged contractually to obtain insurance, such as the ferry flight insurance? And it said when they go and do that, they are acting voluntarily, such that any assignment is not one by operation of law. And what about where a party is obliged to obtain certain insurance as a matter of law, in respect of its employees? It's unlikely to have been the party's intention to have to investigate all these matters, and yet this is a difficulty brought about by Dassault's construction. Another point Dassault makes is that MSI's argument allows the parties to circumvent Article 15 by manufacturing a scenario where you can have an assignment by operation of law. There has been no example given of a different scenario in which MBA could have engineered such an assignment to get around the prohibition. The only example the parties really can come up with is the one you're addressing in the present case, my lords, namely whether an assignment to an insurer is one kind of like that was intended to be caught by Article 15. So their point about us manufacturing something simply raises an entirely illusory issue. There's no actual factual circumstance where our construction is going to allow an unintended result.
Surely the main commercial consequence is that Dassault gets a huge windfall in that it is not held liable for as it otherwise would be, and the party who loses out is an insurer who has no way of knowing about the existence of this assignment, non-assignment clause, because of the confidentiality provision.
Precisely, my lord.
Isn't that the main
bizarre
consequence of the construction?
My lord, yes. We would say precisely so. My lords, if I can be of any further assistance, those are submissions for the appellant.
My lords, I'll deal with my submissions in a moment, but can I just pick up my Lord Justice Phillips's point that he made immediately before I rose? No, my lord, there is no windfall here, and it's important to understand there isn't a windfall. The only question here is who can sue. It is a title to sue problem, not a can you sue problem. Now, as far as the insurer is concerned, one doesn't know. Presumably they couldn't see the contract, but if so, very odd to see what value they attributed to any rights that they had under the contract, and therefore very difficult to see how the contractual rights which they now sue on would have been taken into account by them in any way, shape or form in assessing the risk. But I think that's very far down the road.
Sorry, is there no windfall because you can be sued anyway by MBA?
Exactly, my lord. It's not at all.
So why are we here?
Because we haven't been sued by MBA, we've been sued by MSI. It's a pure jurisdictional question. If MBA has not sued us, but the effect of the decision in this case does not have that effect.
It's quite an important question, isn't it? It's your case is that the assignment under Japanese law still allows MBA to sue in its own name.
Well, if there has not been a transfer of the rights under this policy, of this contract, I'm sorry, my lord, then yes, of course.
Sorry, if there had not been.
If there has not been, if I'm right, if I'm right, then MBA retains all of its rights under the contract, and MBA can continue to sue, as it would be able to under English law after subrogation. Subrogation does not deprive the assured of the right to continue to pursue their claim because it doesn't affect anything.
Sorry, I don't understand that quite.
Sorry.
If you're right,
yes,
then the insurance company cannot sue you under the assignment.
Yes.
Because the assignment under Article 25 was in violation of Article 15.
Yes.
Right? Does that mean that there was no assignment and MBA retains the rights?
Yes, my lord. It must do.
It must do.
There's no assignment for contractual rights.
Correct.
So the contractual rights of MBA against Dassault under the sale contract remain intact.
Yes.
You accept that?
I do. If they were to disappear, that would be obviously absurd. The only question is who holds those rights. Is it MBA or MSI?
And you say it's not for you to concern yourself as to why a claim hasn't been brought in the name of MBA.
No, not for anyone to concern themselves. That cannot affect that ex post facto fact cannot logically affect the construction of the contract. And the only reason I got excited is that if one is looking at construction of the contract, the commercial consequences are those which should be contemplated, and all it affects is who has the claim. It is not about anyone having windfalls. My lords, sorry to have begun on a tendentious note. Can I tell you, lordships, where I'm going and the burden of my submissions? What we know is that a French aerospace company and a Japanese aerospace company agreed in 2015 a particular clause in English in an English law contract that they agreed. It is, in my submission, vanishingly improbable that the meaning of that clause depends on the bankruptcy of pubs in Lambeth in 1815 or...
Don't ruin my day.
The theological, and this is
Sure,
possibly...
they think of little else and take it.
They are very interesting cases in a sense, in a kind of legal historical sense. Yeah. But the fact, rather as what is in the public interest and what is interesting to the public are not the same thing. They are very interesting, but not very helpful, actually, in resolving the debates in this case. And the same actually applies.
Did you say that to the judge?
Yes, I think I did, my lord.
She seems to have been very enthusiastic about them.
Well, they were all referred to, and in fairness, the way this started was that it was this supposed distinction between assignments by operation of law and other assignments, which was said to be seen in English law, which the tribunal focuses on to quite a high degree in its award. Anyway, I'm going to say to my lords that it's really about interpreting the words of this contract. That's the most important point.
Yeah.
And then applying those words to the circumstances which have occurred. So I'm going to address you, my lords, in that order. I will start with the contractual terms seen against their contractual context and so far as it is relevant, the more distant elements of factual matrix. Then I'm going to return to the kind of legal points in the sense of the cases which are said to show this distinction between unwilling assignments and also known as assignments by operation of law and other assignments, and possibly the distinction between the supposedly important distinction between voluntary and involuntary assignments for these.
But I mean, you do have to show, don't you, that a clause that looks like a clause prohibiting acts of the parties to assign assignments, you know, we all know what that means, and that's not something to do with pubs in the 19th century, applies to things that happen by operation of law quite otherwise than by the operation of the party.
I respectfully suggest I don't have to show quite that. All I have to show is that what has happened here is a transfer by a party. Now, that may be the same thing that your lordship has in mind, but as soon as you start saying, as opposed to showing that it takes place by operation of law, you are already glossing the word by as meaning something which carves out something which you're now calling operation of law. That's my only
transfer by operation. All you have to show is that an operation, a transfer that occurs by operation of law, is a transfer by a party.
I have to show that this transfer, as it occurred, was a transfer by a party. That is the beginning and the end, actually, of the contractual issues of the case.
Right.
That's what I have to show.
Right.
So, having looked at the contractual words, I'll look at those laws, and I will then turn, last of all, to set this in the context of English law subrogation and the various questions about how this clause would apply to English law subrogation, to the extent that that is a relevant factor. Now, that argument is, like all arguments of construction, not exactly an A to Z argument, in that one will come back from time to time to different bits of it. In the end, you have to look at all the facets and then decide where you land.
Process of iteration.
I was trying not to say that. I can also tell you...
Shall we say it or not say it at 2 o'clock?
Let's not say it at 2 o'clock, and I will start with a contractual language at 2 o'clock.
2 o'clock.
Court rise if able.